Welcome back everybody to the Law of Tort. In this video we're going to move on away from looking at negligence and the duty of care, and we're going to start to talk about the concept of the breach of said duty of care. Now this has been a very long series of videos so far already, just looking at negligence, and we've only spent all of our time so far talking about the various different concepts and relationships to the duty of care and the subsidiary issues relating to different types of harm, so psychiatric harm and pure economic loss. This lesson and the next few lessons is going to be covering the next major topic, which is of course the concept of the breach of the duty of care and the standard of care by which a breach has to be shown to have been determinate. We will then go on to talking about the fact that we have to then have causation. We have to have causation in fact, and we also have to have causation in law. We'll look at what these two things mean in the next few lessons after we have covered the breach of duty. So, like I said, we're moving away from the subsidiary issues which pertain to the law of negligence. We obviously talk about the concept of psychiatric injury as a type of damage which can be attributable in negligence cases. Some of which are psychiatric injury, which are essentially consequential onto the damage that is physical injury or some kind of other kind of injury. And then there is also this concept of pure psychiatric harm. The idea that there is not actually a physical injury which takes place, but that there is some traumatic event to which affects an individual, which affects a claimant in only psychiatric harm, in a recognized psychiatric condition. We then spoke about the difference between pure and consequential economic loss. Economic loss, which is consequential on some kind of tangible and real damage that is caused to a claimant, is valid. So, for example, if you were in a workplace accident, the result of which caused you to have a physical injury, and the result of which causes you to have time off work at a lower rate of pay, maybe you only get sick pay, then that loss of revenue would represent consequential economic loss. But then we also noted that there is no claim for something known as pure economic loss, whereas the result of negligence, there is some kind of loss that is taken, and that loss is only economic in nature. It is not attached to any sort of physical damage or damage to property or psychiatric injury, etc., etc. We then looked finally at one of the major exceptions to this rule of pure economic loss, which is through the concept of negligent misstatement and the Hedley-Byrne and Heller principle as established and then re-established in subsequent case laws. So that's what the last few lessons were covering. This lesson is going to talk, like I said, about the next major hurdle in the establishment of a negligence case, this being trying to establish that there not only was there a duty of care, but that the actions of the defendant rose to the level of breaching that duty of care. Remember then, the negligence equation is as follows. There has to be a duty of care plus a breach of duty of care plus the causation of all of those actions to the damage that was caused by the claimant to the defendant. This then results in negligence. This next series of lessons is going to be talking about what is highlighted in red, the idea of there being a breach of a duty of care. So essentially, once it has been established that the defendant in question has a duty to take care to the claimant in the particular circumstance, it must then be shown that their actions or their lack of actions went and went to the level of breaching this duty of care. Okay, so that this standard was breached such that the damage was caused, which would then have been the result of this negligent action on the part of the defendant. The main consideration that we have to take into account when we think about what and how we can show a breach of a duty of care is to talk about the standard. The standard which is to be expected in the particular circumstances, as well as the extent to which the claimants had acted outside of this standard. So there will be, and we will see and show that there exists a standard of care, a standard by which every single person who has a duty of care has to essentially meet that standard. You have to go up to that standard at the very, very least. And for those of you who have gone below that standard, who have not managed to reach the standard of care, you have therefore breached that duty of care, and the resulting damage that is caused to a claimant, if we can show causation, would therefore result in a successful negligence case. So this is known as the standard of care, and the standard of care is something that we're going to spend a lot of time exploring in this series of lessons. It refers to, like I've mentioned, the appropriate level of care which is to be expected of the defendant. Okay, the standard of care does not imply that defendants have to go above and beyond what is reasonably expected to ensure that there is no harm that is done to a claimant, but they have to at least have done the bare minimum. The bare minimum being this line, this standard of care. If there is a breach of duty, then this breach must be below the ordinary standard which is expected. So the only way in which you can show a breach of a duty of care is if you can show that they have fallen below this standard in their actions or their omissions, which leads to the damage in question. If the defendant is acting in accordance with the ordinary standard of care and the claimant is still injured, then it is held that it cannot be the result of the defendant's breach of duty for them to have been injured, and therefore no negligence claim can happen. Remember, negligence is there being a duty of care to a claimant, and that this duty of care is breached by the actions or the omissions of the defendant. And so in order to really show the breach element of a duty of care, of negligence in general, they have to fall below this ordinary standard.